All right, hey everyone, welcome to episode 39 of Trucksafe Live, the show where we and our guest tackle the hot button issues impacting highway transportation. I'm Brandon with Trucksafe and Childress Law, both of which are dedicated to helping motor carriers develop and maintain cutting edge safety programs. Got Rob Carpenter with me today. Rob is on assignment somewhere out there driving a truck. Hey Rob, what's up?
Hey, not a whole lot. I'm on my break. You know, we got to be
on your break, a 30-minute rest break?
Truck. Yeah, it's going to be an hour today, but it'll work.
Yeah, the show usually goes a little over 30 minutes, but if you need to go, feel free and go. How's the open road treating you today?
It's good. It's hot.
You're in the Midwest?
Yeah, we're in Missouri today, so it's a little warm.
All right. Well, today's episode is all about carrier safety ratings. Timely topic. FMCSA came out with an advance notice of proposed rulemaking on this topic last year at some point, and they are starting to revisit the topic. They've got a couple of listening sessions in store, so we wanted to pop on here and talk about the importance of safety ratings, so folks that are going to be attending the listening sessions or offering their comments to the rulemaking can be better informed on the existing state of things and the possibility of where FMCSA may be taking these things. So that's what we want to do on today's show. Before we get there, I want to first thank the sponsor of this episode, which is Taking the Higher Road, a legacy builders and freight waves production. Taking the Higher Road is a special podcast dedicated to addressing the trucking industry's greatest challenges: driver recruiting, retention, and compliance. Each week, host Jeremy Raymer, 20-year industry veteran and founder of Driver Reach and Legacy Builders, interviews industry experts and thought leaders who bring their insights to the driver life cycle. Be sure to check them out wherever you get your podcasts. Thanks again to Taking the Higher Road for sponsoring this episode. Before we get to the main topic, as always, a few things going on at Trucksafe and in the industry that are worth mentioning. On the Trucksafe front, first up, we'll mention our upcoming Fleet Compliance Boot Camp, which is going to be in Indianapolis, September 25th through the 26th. Be sure to join us. This is our 2-day in-person conference where Rob, me, and Jared, and Brian, and others spend that time going into the DOT regulations ad nauseum, hitting on all the major topics: driver qualification, hours of service, vehicle maintenance, drug and alcohol testing, DOT enforcement, and all that fun stuff. Really digging into the nitty gritty and helping attendees to start to develop cutting edge safety programs back home. We have a lot of in addition to the educational sessions, we do a lot of exercises like driver qualification reviews and hours of service, log auditing, and that type of stuff. Like I said, all to equip attendees with the information and the knowledge they need to build effective safety programs back home. If you're interested in joining us, head over to trucksafebootcamp.com. Seats will fill up quick. Again, this is going to be September 25th and 26th, so be sure to register soon if you want to join us. That's the Trucksafe Bootcamp. What else we got going on? E-Regs, you saw the video at the start. Be sure to check out E-Regs if you haven't already. This is the first app-based digital version of the Federal Motor Carrier Safety Regulations, available at eregs.app. You can try it out for free for 14 days by signing up over there. This is the software that we built, spent the last couple of years building to help fleets not only just access the regulatory text like you would do with the green books, but more importantly, access all of our educational materials that goes along with it. So if you're reading about the short haul exemption, for example, then you would have access to all of our videos and articles on that topic right next to the regulation to make it easy to dig even further into those regulations as you're reading them, which is particularly helpful, we found, for complex topics like split sleeper berth, just to name a few. You taking advantage of the split sleeper berth, Rob, while you're out there?
No, I'm trying to keep. I like the schedule. You know what I mean? It's a lot of truck drivers are just like place to place where they end up. I like to plan this thing and stop where I want to stop and sleep at night and be awake during the day and then go home and get it over with.
Yeah, Makes sense. Anyway, you can check that out over at eregs.app. Also has the FMCSA's guidance for all the regulations right there in a convenient place for you. And you also have the ability to annotate the regulations with your own notes, highlights, and bookmarks. Check that out, eregs.app. Lastly, I'll mention Trucksafe Compliance Network, trucksafenetwork.com. This is our dedicated space for safety professionals to gather together, learn from one another, ask questions, and also access all of our DOT content, including our videos, articles, podcasts, webinars. We're in the middle of a 7-part webinar series right now on improving CSA scores. We've been through hours of service, unsafe driving, and vehicle maintenance. We've got crash indicator, driver fitness, hazmat, and drug and alcohol to go. But network members get access to that for free, along with a bunch of other helpful information. So check that out. Free to join, trucksafenetwork.com, or download the Trucksafe Network app in the App Store or the Google Play Store from your mobile device. All right, enough about us. Let's talk about some other things going on in the industry before we talk about carrier safety ratings. Not a whole lot that I want to talk about today, but the first thing I noticed that came out earlier this week was an announcement from FMCSA that they are increasing the Unified Carrier Registration UCR fees for 2025. This comes on the heels of a couple of years, I think, where the fees have been lowered slightly or have decreased slightly. Now they are proposing an increase. According to the notice, which came out, like I said, earlier this week, the fees for the 2025 registration year will be increased above the fees for the 2024 registration year by an average of 25% overall, with varying increases between $9 and $9,000 per entity. That's quite a big range there. So be on the lookout for that. These will be your use if you're an interstate fleet. You are, whether you know it or not, you're supposed to be paying UCR fees in connection with your DOT account, and the fees are based on your fleet size. The smaller the fleet, the lower the fee bracket that they are in, and obviously the larger the fleet, the more you pay in UCR fees. But overall, they will be increasing by about 25% across the board for 2025. So fleets, you have that to look forward to in 2025, unfortunately. Rob, any thoughts on UCR fees that we need to?
Insult to injury is the first thought, but the fact that it's going up, it's not really a good year for it. I mean, a lot of carriers are struggling right now. Actually, most carriers are struggling right now. So they could have just left it lower for another year at least. Try to let this thing recover.
There were a lot of comments on it, as you might expect. Let's see what the numbers are going to be. They've got a table in here somewhere. Man, this was a long, unnecessarily long final rule that is
hey, we're going to raise this 25% and just leave it at
cow.
that.
I didn't know it was this long. Okay, so here's the fee table for 2024 and then 2025. So you could see at the lowest fee bracket for fleets of between 0 and 2 power units, which is the majority of interstate fleets in the country, it's going from $37 per year to $46. So that's the $9 jump. That's nothing to write home about. But you could see that the highest fee bracket for the mega fleets, 1,001 trucks or above, in 2024 you paid about $36,000 per year, and next year you can expect to pay about $45,000 per year. So like I said, 25% increase across the board. All right, so that's UCR fees. Saw that notice come through, wanted to mention it. The other thing I saw come through this week was this story that is making the rounds about this new Schneider case. It's a nuclear verdict case. Like we've talked about for the last seems like decade at this point, these nuclear verdict cases, verdicts against trucking companies in excess of $10 million continue to be on the rise, and this is just the latest example of one. The title of this article is Jury Slams Schneider National with a $47 million nuclear verdict in fatal crash. I just wanted to kind of run through this. You all can read the article on your own time, but just wanted to hit the highlights here. Georgia jury recently awarded more than $47 million to the family of a 35-year-old owner-operator who was killed in an August 2017 crash involving a former company driver for Wisconsin-based Schneider National Carriers. Now, if anybody's read this article, you'll know that the facts are a little convoluted here. In fact, the title of this subsection here is "What Happened." It's complicated. According to court documents, the owner of Nance Truckin' LLC was struck and killed in 2017 after exiting his tractor. Investigators arrived at the scene of the crash. Nance was forced to brake suddenly and steer his tractor into the emergency lane, striking the concrete median on southbound Interstate 285. Philip Taylor, who was driving a pickup truck, told investigators that a driver named Joaquin was driving a white tractor trailer for Schneider, swerved across multiple lanes of traffic and into Taylor's lane, forcing him into the left lane and onto the shoulder where he struck and killed Nance. So that's Schneider's alleged involvement, is a driver who supposedly swerved into the lane, causing the tractor trailer to drive into the median and kill Nance. It's interesting if you read down on about this case into the article, you'll see that the Schneider driver denies that he was anywhere near the scene. They end up getting a hold of GPS records and placing him near the scene, and that's what ends up. That's the sole hook for Schneider in this case, and we end up with a $47 million verdict against Schneider. You'll also read in that article that there's evidence about the Schneider drivers who was allegedly the one that swerved and caused the accident. There's evidence in the record about his driving history, including some drug and alcohol violations in his past. And the one that I thought was interesting, let's see here. Yeah, his Qualcomm records obtained by Nance's attorney documented that he amassed several critical driving events for hard braking and stability control issues. His MVR report showed that he'd been involved in multiple crashes over his 7-month employment with Schneider. 4 days after becoming a dedicated driver, he testified that his supervisor told him that Schneider's predictive analytics software sensed that he would be crashing soon, which can't be good. Schneider allegedly did nothing to help him. And then in his 3-month performance improvement plan at Schneider, his dispatcher documented in his employment record that he had received 5 more critical event notices prior to being fired. So obviously none of this worked to Schneider's benefit in the context of this litigation, even though many would argue that all of this stuff in this particular driver's past is really beside the point in relation to the accident at hand. It clearly inflamed the jury and led to a $47 million jury verdict against Schneider. So the point is, doesn't really matter if you're physically involved in the crash. If you've got these kind of skeletons in your closet as a carrier or as a driver, you're at risk for a pretty significant jury verdict. Thoughts on that, Rob?
No, it kind of bleeds into the same ratings discussion that we're going to have. Like, obviously the FMCSA rates you based on different criteria, but there's different things that you can do internally where you're rating drivers, and it can come back to bite you if you're not managing those rating systems effectively. So when you're getting those events and you're not doing anything about them, it's an important consideration, because eventually it could come back to bite you in court if you have that crash. So it's a big deal.
Yeah, we've talked about that on past shows and some of the webinars we've had over the years, the importance of managing the data that you have coming into you, flowing into your systems, making sure, number one, you know what data is coming into your systems, and making sure you have the processes, the people, the policies in place to effectively manage it. Because if it turns out that you are turning a blind eye to things that the data is telling you could be a problem, namely driver behavior type stuff, then it is just not going to play well for you if these things happen. And, obviously these things are rare. They don't happen very often, but when they do happen, if these things are going to come out in that litigation, it's not going to play out well for you. So make sure when it comes to data specifically from telematics devices, from your ELDs, from your cameras, whatever connected technology you have in the truck, make sure that you have the processes and people in place to manage it, and that you are effectively working it from month to month and taking appropriate action when necessary. All right, so that's kind of things I wanted to mention about industry developments over the last couple of weeks since we had our last show. Let's move into the topic of today, which we've talked about is carrier safety ratings, safety fitness determinations, also known as safety ratings, which we've described in the past as a motor carrier's regulatory lifeblood. They are what dictates whether a carrier is able to operate commercial motor vehicles or not, and whether shippers and brokers and insurers want to do business with them or not. So critically important safety metrics for many reasons, and they could be changing drastically in the future. So that's what we wanted to hit on today. So first up, just wanted to mention, like I did at the start, that this is all spurred on by the FMCSA's notice from last year. It's an advance notice of proposed rulemaking, which essentially says, if you know anything about the rulemaking process, you'll know that this is very early on in the rulemaking process. An advance notice of proposed rulemaking is just where the FMCSA is coming out and saying, hey, we are thinking about changing up our rules in some form or fashion. What do you think about it? And usually they'll ask a few questions to get the public to weigh in on, and then they will solicit comments through the regulatory comment period or comment process, and then also they will sometimes hold listening sessions where they either show up physically on site somewhere and have a discussion with folks in attendance, or they do them via Zoom or something of that nature, and that's where we're at in this particular process when it comes to safety fitness determinations. FMCSA published this ANPRM last year, 2023, opened the comment period for, I think they ended up opening it for about 60 days or so. That comment period is closed as far as I know, but they are still soliciting public input, and they just announced within the last couple of weeks that FMCSA will be holding some listening sessions on this rulemaking specifically over the coming months. In particular, actually, this just was published today in the Federal Register. Let me pull it up. If anybody's interested in attending these listening sessions, the first one's going to be a virtual public listening session. It will be held on Tuesday, June 25th, from 2 p.m. to 3:30 p.m. Eastern Time. And there's a link in the Federal Register notice where you could see the agenda for the meeting, and also where you can register to attend that listening session. Second one will be another virtual one. It will be held on July 31st from 2 to 3:30 p.m. Eastern Time. Again, information is in the Federal Register notice. And then they are also going to have an in-person listening session. Wanted to see if that information is in this notice. I don't think it's in this particular notice, but I know they are having an in-person listening session. Oh, was that it? Yeah, here we go. In-person listening session in Houston, Texas, I think at the Texas Trucking Show, June 2024.
I think it's the 27th through the 29th is the trucking show.
Okay, so it's one of those days. They don't have the date in this particular notice. They just say it's in June 2024, but I think you're right. I think it's probably the 28th or the 29th would be my guess of June. If you're at the Texas Trucking Show, then maybe you can attend in person. But anyway, that's kind of where we're at in the rulemaking process. But before we get into the specific questions, because I think it'll be interesting to walk through these questions that the FMCSA is asking in both the advance notice of proposed rulemaking and also in their notice about the listening sessions, to first take a look back at kind of where we are at currently with safety ratings and how they are assessed or how they are generated currently, so we know we know what to expect if FMCSA goes through with their rulemaking process. So just kind of walking through the current safety rating process. Anybody familiar with this knows that we currently have a 3-tiered rating system. Right now, a motor carrier can have a safety rating of either satisfactory, conditional, or unsatisfactory. We have had this rating system in place for decades at this point. This is the way that the FMCSA, the primary way historically, that FMCSA has judged the safety fitness of motor carriers that it regulates, as Congress has directed it to do in its enabling statutes that set up the FMCSA to begin with. Congress has told FMCSA that they need to have a method by which to judge the safety fitness of motor carriers that it regulates, and historically safety ratings, the 3-tier rating system, has been the way that they have done it. That rating system currently and historically has required FMCSA to conduct a compliance review in order to issue a safety rating to a motor carrier. It requires the FMCSA to physically look at records for the motor carriers to whom they issue the safety ratings. That either on-site compliance reviews, or more frequently nowadays off-site reviews. It doesn't matter. Whichever way they are looking at your records, if they are snooping around in your driver qualification files or your maintenance files or your drug and alcohol records, that's what it takes for the FMCSA to issue you a safety rating. And what that practically means is that most of the motor carriers operating in the United States today have no safety rating because they haven't gone through that type of a compliance review from FMCSA. In fact, I think I've got the data here. Let me pull it up. Yeah.
It's the majority for sure. But
Yeah.
I've always thought this was kind of scary because we've seen carriers and we've been to different ones, and it's like, if you look at their systems, it can be just abysmal, and they might have an unrated, which means, your broker's still going to work with you in most cases because you're not conditional, and you're still out there able to operate. So I've always thought it was a little bit off, but
maybe it made more sense back when FMCSA had fewer carriers to regulate, but nowadays we're up over 700,000 motor carriers, which fall under the purview of the FMCSA. And you can see from this data that we're showing on screen here, this data is already old at this point. This is from the FMCSA's, I think, 2022 large bus and truck crash study. They show here a chart which indicates how many motor carriers there are registered and how many of them have no safety rating. And you could see that as of 2021, there were over 738,000 regulated motor carriers, and only 690,000 of those carriers have no safety rating, which I think ends up being about 95% of the regulated motor carriers in the United States are unrated. And to Rob's point, that means that they have never been reviewed by FMCSA, at least in depth, in terms of kind of a records review. And so they are out there operating with no safety fitness determination. And is that a good thing? Is that a bad thing? That's what we're going to get into. That's what the FMCSA is looking into in the context of this rulemaking for sure. But that's kind of where things stand currently. And one of the major driving forces for this rulemaking, in my view, and not just my view. This is what the FMCSA says in its advanced notice of proposed rulemaking, is that their inability to effectively go out and do compliance reviews for any significant percentage of the carriers that they regulate is a problem in their eyes, and it's what's driving this rulemaking going forward.
Well, I think a lot of it gets started on the wrong foot. When, a lot of these companies will get started, they have no idea what they're doing, and they're just ignorant to what they should, the processes and the systems that they should have in place. It's especially true with like the old school carriers who came along and were created years before a lot of these rules even came to be. So, there was one carrier that I know of that I worked with that was 50 years old, and they had no DQ files at all. They had no drug testing program. They'd been in business for 50 or 60 years and had never had a compliance review. So they're still operating, and they just don't have any programs in place because they never have had them. So the new entrant piece I was glad to see, because I think the new entrant piece kind of sets the educational tone piece when you're starting your motor carrier operation, to say, hey, you need the following systems, you need the following processes, and if you don't have them, we're going to educate you on what you need. And that was a good, I think, initial step to kind of guiding carriers into what they should have and how they should operate. But I think prior to that, there was a lot that started just on the wrong foot. So
yeah, the new entrant program, I agree, is a good step. But those new entrant audits, as many will know, are not the types of audits that result in a safety rating. So even if you fail a new entrant audit and then ultimately you get put back in service, you're not going to get a safety rating out of a new entrant audit. So it takes a more thorough compliance review to get assigned a safety rating. And just kind of looking at the methodology for this in the regulations, if you go to Part 385 of the Federal Motor Carrier Safety Regulations, that's where you'll find the detailed methodology that the FMCSA currently follows to when conducting its compliance reviews and issuing a safety rating. And again, that's what we've been going off of for decades. Like, for example, when Rob and I go do mock DOT audits for a lot of our carrier clients, we try and follow the same methodology that the FMCSA uses to give carriers a good feel for how they may fare in the event of a real audit. And so here's how it works, generally speaking, and Rob, fill in the gaps here as we go if I miss anything. But when the FMCSA comes in, well, first of all, how do they decide who is going to be audited in your view, Rob? Who are the carriers that get selected for compliance reviews?
So once you go over, each basic has its own threshold. So a lot of times it's basic. It starts with basic violations. So your violations are going to increase your threshold for each basic category. And then that kind of starts with the letter that's going to say, hey, we've noticed an uptick in your maintenance violations at the roadside. And if you don't get this under control and you don't figure it out on your own, we may be coming to see you soon. So if you don't take some kind of action to determine what your problems are, whether they're systemic or whatever the issue is, and then you address them and try to get that threshold percentage drawn down, then you may have a compliance review. Other ways you can have them is, I've seen fatality crashes kick off on a compliance review. So different ways, different pieces, but a lot of times I think they really focus more on habitual behavior. So it goes more towards the threshold piece than the fatality piece.
Yeah. And then also, I think that's right. Those are the two most common contributors to a compliance review. Far and away, the CSA scores and alert status are kind of what triggers audits nowadays. SMS, as if anybody who is following along with us on our webinar series on improving CSA scores, you'll know that high CSA scores are a very common contributor to DOT audits, and the reason being the SMS system, the CSA score system, is really intended at identifying patterns of non-compliance, so systemic problems in a carrier's safety and compliance across the 7 basics that Rob mentioned. And as your scores start to tick up in one or more of those basics, the more likely it is you're going to get a knock at the door from the FMCSA to conduct a compliance review. But also fatality accidents certainly can prompt an audit. They don't always prompt an audit, but sometimes they do, particularly if they're bad accidents that get a lot of publicity. And then the other one that we see pretty regularly prompt a DOT audit are complaints from drivers. So if you tick off a driver and the driver leaves and he files a complaint with FMCSA alleging hours of service, systemic hours of service violations, for example, which is a pretty common thing to happen, FMCSA will sometimes investigate that, and that could prompt a DOT audit. So several things could prompt the audit. Once they are in there, once they have selected you for an audit, they can conduct a couple of different types of audits. I'm using the term audit generally. They have different names for these. Compliance review is the most common. But they can do what are called focused audits, or they can do comprehensive audits, or they can do some combination of both. Usually, in my experience, particularly nowadays, audits will often start out as a focused audit, meaning they are focused on a particular area of compliance. So in that example that I gave, if a driver complains that you are a fleet that is running drivers into hours of service violations, they may come in and look at the start, at least, just at your hours of service program and see if they can corroborate that driver's complaints. But what often happens is that an audit may very well start out as a focused one in a particular area of compliance, and it may balloon into a more thorough audit, a comprehensive audit. Ultimately, there are 6 factors that the FMCSA would look at if it were going to be a comprehensive audit. Those factors are general compliance, which is going to be things like, do you have the right insurance, and stuff like that. Then you've got the driver factor, which is factor 2. That encompasses both driver qualification files and also drug and alcohol testing if you have CDL drivers. Factor 3 would be the operational factor, which are hours of service rules primarily. Factor 4 is the vehicle maintenance factor. Factor 5 is hazmat, if you haul any hazmat. And then factor 6 is your accident rate. How many DOT recordable accidents have you incurred per million miles that your fleet has traveled? And those are the 6 factors that if the DOT is conducting a comprehensive compliance review, the investigator will be looking at. They are going to be selecting a sample of records in each of those factors according to a sampling methodology that they have detailed in a very voluminous document called their EFOTM, Electronic Field Operation Training Manual, I think is what it stands for. And they're going to pick their sample of driver files, for example, hours of service records, vehicle maintenance records, and they're going to send you information requests, and then you are expected to have the documents that they've selected to them within 48 hours. That's all you get. And these are not random samples. They are not randomly picking the driver files that they want to see or the vehicle maintenance files they want to see. What they are doing is going into your safety measurement system account. They're seeing which drivers are having driver fitness problems, which drivers have been operating without the right license from roadside inspection data that they have available to them. They're going to pick those drivers that are struggling. They're going to pick the drivers that have had the most hours of service violations. They're going to pick the vehicles that have been incurring the most vehicle maintenance violations roadside. And those are who you as the motor carrier are going to be judged against, are your worst performing drivers and your worst performing vehicles. At least that's what I've seen. Is that what you've seen as well, Rob?
Yeah, usually I tell people that count on getting the ones that have the most violations, the ones that are on the accident registry the most frequent, and if you happen to need space fillers, it's going to be somebody. So, yeah, but it's definitely not random. So they usually have a pretty good list to choose from.
So if you wanted to prepare, if you're a fleet right now out there that wants to prepare yourself for a mock DOT audit, the best thing you could do right now is go in your SMS account, look at your worst performing drivers, your worst performing vehicles, get all of those issues taken care of first and start to work your way down, because like I said, you're going to be judged by your worst performing. So go ahead, and if you have drivers that have been tagged with CDL violations or missing med card violations, get all that stuff taken care of ahead of time. And that will go a long way in preparing you for an audit if it ever comes to be. And so that's how it works. The investigator picks their sample from that list. They will send you an information request. The audit will either be offsite or on-site, depending on their preference. And you better have those documents available for them when they are ready to look at them.
Yeah, I think the only piece that I've seen it happen at least 3 or 4 times where, they'll exhaust their bad drivers either from violations or the drivers who are constantly on the accident registry. And then they'll say, all right, we need 4 more. Give me the 4 drivers that drive for you the most frequent. And I've had that one come up a lot where they want the drivers who are operating all the time. So that's another one that they like to choose from.
Yeah, they obviously have to do their own diligence and make sure that if they're going to write you up for a violation as the motor carrier, that they have evidence to prove that that driver was actually subject to the regulations when the alleged violation occurred. So, for example, if they're trying to prove a driver has an hours of service violation, one of the things they have to prove is that the driver was subject to those rules to begin with, meaning were they operating a commercial motor vehicle in interstate commerce at the time. And so then you'll see a lot of times that they are also requesting supporting documents to help them prove that the driver was in fact subject to the rules and then violated them. So things like bills of lading, that type of stuff to prove that this driver was hauling these goods from this location to that location on this date in a vehicle that weighed this much, and that gets them the information they need to substantiate their violations. But anyway, in those 6 factors, that's kind of what they're doing. They're going to look at all of the documents you've produced, and they're going to be looking for paperwork violations, essentially, in all of those 6 factors that I mentioned, if they're doing a comprehensive review. And then they are keeping track of every little violation that they discover. There is a list in Part 385, in Appendix B, I think, to Part 385 of the safety regulations that dictates what are called acute and critical level violations. It's a list of probably 100 or 200 or so particular sections of the regulations, and those are the ones that are either acute or critical. What does acute and critical mean? These are the more serious violations. Acute violations are the most serious violations that an investigator could discover in a DOT audit. And it only takes one of them, only one instance of that violation to potentially negatively impact your safety rating. If they find one of them, then it's going to potentially impact your safety rating. A good example would be continuing to use a driver after you know that he or she has tested positive for a DOT drug or alcohol test, for example, without them going through the return to duty process. Critical level violations are still serious, but it takes a pattern of non-compliance to amount to a critical level violation. So they're looking for not just one violation, they're looking for multiple violations of that same kind across the files that they've been provided. And the violation rate that would amount to a critical level violation is 10% or more. So a good example of this are log falsifications in the hours of service factor. They are going to be digging through a certain number of drivers' logs over a certain time period, and if they find more than 10% of the driver's logs that they're looking at are falsified, well, then that's going to amount to a critical level violation in factor 3, the hours of service factor. And so I mention this because, like I said, these acute and critical violations are the ones you're trying to avoid at all costs, because they are the ones that set your safety rating. You can get away with all of the ticky-tack violations and maybe only get a slap on the wrist in terms of like a fine coming out of that audit. But if you start incurring critical and or acute level violations, that's when your safety rating is at risk. And so that's what we're trying to avoid in these audits. Sean says here, sorry, I probably missed it. How many drivers do they select? So in the eFotum that I mentioned earlier, it sets out the sampling size in each of the different factors that they're looking at, or for each of the different document types they're looking at. That used to be publicly available, but I think they've redacted it since they published the eFotum on their website. I don't know why they've redacted it. I don't know why that is considered proprietary or confidential. I think motor carriers should have access to that information so that they can do their own mock DOT audits and stuff like that. But in any event, it depends largely on the size of the fleet. So the larger the fleet, the bigger the sample size is going to be, and the sample size differs in each of the different factors. So how many DQ files are they going to pull is different than how many driver logs they're going to pull. But it's all generally driven by how big the fleet is based on the fleet size.
I think I generally, when I'm doing mocks, I'll do like 25%, but that's not their rule. That's just me trying to get a big picture of how you operate and things that you may need to improve. So that's a good rule of thumb, I think. So that's generally my go-to.
Yeah, I pulled down an old copy of that sampling methodology, so I've got it saved. So there, FMCSA, take that. I've got it saved on my computer, so I know what the sampling sizes are, unless they've changed them, which I don't think that they have. But yeah, I mean, for a fleet of 100 drivers, I think it roughly equates to maybe 25% of the files in each of the different factors. But yeah, I think like the largest sample size of hours of service records, for example, for the mega fleets, the highest they go though is like 30 days worth of logs for 27 drivers, I think is always what it was. So 800 and some on-duty days of logs that they're looking at for the largest carriers in the country. And that's what they're basing their 10% threshold on for purposes of determining whether there's been a critical level violation or not. So that's how it goes from factor to factor. They're identifying critical and acute violations. And then there is in Part 385 a table that dictates what your safety rating is going to be based on how many critical and acute violations they find. You get a rating in each of those 6 factors of either satisfactory, conditional, or unsatisfactory. And then you get an overall proposed safety rating based on the ratings in each of those individual factors. The thing that a lot of fleets don't understand, but it bites a lot of them, and it's probably the number one reason we have fleets coming to us with a downgraded safety rating, is that of all those 6 factors I mentioned, there's one of those factors that the FMCSA apparently deems more important than the others, and it double weights all violations that are discovered in it, and that's the hours of service factor, factor 3. And practically what that means is that if they find a single critical level violation in factor 3, so 10% of your logs are falsified for one reason or another, because of the double weighting in that factor, that means that you automatically fail that factor of the audit, you get an unsatisfactory rating in factor 3. And if you've seen the table for the safety rating methodology, you'll know that you can't get out of a DOT audit with a unsatisfactory factor with anything better than an overall conditional safety rating. So all it takes is one critical level violation in hours of service, and you have a proposed conditional rating coming out of that audit. So like I said, far and away the most common contributor to conditional safety ratings or downgraded ratings in general that we see coming in. I know, Rob, you're dealing with several at any given moment, helping carriers get their ratings back after they were downgraded. That's probably the most common one you see, isn't it?
Yeah, we actually had a significant one recently. I guess it was end of last year, early this year, and the carrier was closed for 3 or 4 months, and 146 of their violations were critical hours of service. So, it's a larger company, so they had a huge driver population that had no work, so they couldn't operate. And I think a lot of carriers miss that piece, that they can be shut down and closed based on compliance factors. So
this is why we call safety ratings your regulatory lifeblood, because if you get an unsatisfactory safety rating that becomes final after a DOT compliance review, your entire fleet is going to be shut down. Not just one truck, not just one driver, not just the ones that they found violations on. Your entire fleet is going to be prohibited from operating commercial vehicles in both interstate and intrastate commerce, unless and until you do the work to get that rating upgraded, which takes a lot of work. A lot of fleets don't realize that either, that it's not just a thing where you go and beg for mercy and then maybe you say, hey, we've corrected these issues. No, it requires you to put in the work to actually correct the issues, and the FMCSA is going to check you on that. You have to submit what's called a safety management plan, and it has to document in excruciating detail the steps you've taken to fix all the critical and or acute violations that were discovered in that audit, and they have to be to the satisfaction of the FMCSA. And if it's not to their satisfaction, they're not going to let you back in business. So an unsatisfactory rating coming out of a DOT audit can be the death knell for carriers that aren't interested in putting in the work to fix the issues, or maybe they get shut down and now they have no revenue flowing in. They just don't have the means to fight that battle anymore. So a lot of carriers fold because of unsat ratings, but that's the biggest consequence. That's the most serious consequence coming out of an audit. But conditional ratings are also serious. That's the middle ground rating that you could get following a compliance review. They don't end up shutting your entire fleet down with a conditional rating. You can continue operating vehicles on the roads, at least according to FMCSA, but it does have serious consequences in other contexts. For example, a lot of shippers and brokers nowadays, they have in their contracts with you that we don't do business with a carrier that has a conditional safety rating. They won't tender loads to you if you have a conditional rating because of the exposure they have from using a carrier that's been tagged with a conditional rating. It also can jack up your insurance premiums if you get a conditional rating, and it certainly places a bigger target on your back from a highway accident litigation standpoint if you got a conditional rating.
Yeah, and I have we have pretty frequently insurance companies who will reach out and say, hey, I've got this guy, he wants to renew his policy. We can't renew it because his safety record from this past so many months is just gone abysmal. So can you work with them to do data queues and to actually fix their program? Because the insurance companies won't want to renew your insurance if you already have a policy in some cases, and until you fix some of these things. And brokers, when they accept your carrier pack, before they'll even let you come on as a carrier, they want to make sure that your rating is generally either unrated or satisfactory, because if you're conditional, they're not going to pick you up in most cases. I mean, there's probably some out there that would, but your reputable brokers that you want to work for are not going to want to do business with you with a conditional rating. And that unsat is just a killer because, like Brandon said, if you don't have the financial ability and the financial backing to last for, in some cases, months to get that rating improved, to get back open, you could easily run out of funds. Because when you're at that unsat level, you're really at a place where they don't really have to do anything for you because they've kind of got you over a barrel. You're already unsat. You're not operating. So you're not really a priority for them. So you have to basically do the back and forth to get that rating upgraded. And it can go back and forth several times before they finally agree to let you open back up.
Yeah, now there is some timing to it. So last thing I'll mention about the current rating process is that there are appeal options. There are options for carriers that end up with the rating is considered proposed for a certain period of time after it's issued following an audit. If you're a hazmat carrier, it's considered proposed for 45 days. If you're a non-hazmat carrier, it's proposed for 60 days. And within that time frame, you have two options essentially available to you. You can either appeal the rating if you believe that it was the rating was assigned in error, meaning that the investigator made some kind of a legal issue or a legal mistake in assigning violations. Those appeals get tried by the FMCSA's chief safety officer at FMCSA's headquarters. There's some briefing involved. You get to brief the issues. The FMCSA service center that issued the rating gets to brief the issues, and then the chief safety officer decides the matter. And then if you lose on there, then there are some options available to you to take it to federal court. The more common option, though, is the corrective action option. So this would be in section 385.17 of the safety regulations. This is where you aren't necessarily contesting the violations that were issued in the audit, but you are telling the FMCSA you acknowledge them, but you've corrected them since the audit, and here is the evidence of our corrective action. It's a safety management plan that you file, and like I mentioned, it better be very detailed and thorough, or else it's just going to be denied. But anyway, if you are successful in either of those options within the time frames, then maybe your rating gets upgraded before it ever becomes final, and then nobody ever knows that you had a close call with a downgraded safety rating. But otherwise, if those timeframes expire and the FMCSA hasn't ruled on your request, or they've denied your request, or you waited too long to file the request, then those ratings will become final on those deadlines, 60th or the 45th day. And if it's unsatisfactory, that's when you'll be shut down. Your authority will be revoked. The state police will show up at your door in some cases and start pulling the plates off your vehicles, and you're done for at that point. If it's a conditional rating, then it becomes effective on that particular date, and then it's going to be publicly available for anybody to find after that on the Safer website and SMS and stuff like that. It's also going to be distributed out to all the platforms that are watching those types of metrics for your customers. Carrier 411, Carrier Assure, all of those things are going to get notification that you now have a downgraded safety rating, and that's going to cause problems for you, undoubtedly.
One of those things to consider is the time frame of that back and forth. So if you get that unsat, it's very real. So it may not go into effect immediately, but it will go into effect after that pending period. And if you contact somebody like Trucksafe for us to help you get that safety upgrade 9 days or a week before it goes into effect, keep in mind that you're probably going to still be closed, because we can't do that back and forth process with FMCSA in a matter of 5 days. So once you submit it, if you submit it on your own or whether we submit it for you, it's still going to take that back and forth between us and the FMCSA to kind of negotiate that piece out and to work out any kinks that are in that safety management plan. So if you're going to start working on it, you need to start working on it the day the compliance review is over, so that you kind of have the ball rolling, and hopefully you never have to face the finality of it. You can resolve it beforehand.
Yeah, because the best case scenario, obviously, aside from showing what corrective actions you've done to hopefully fix the issues, ideally you would like to show the FMCSA not only that you've done the corrective actions, but that they are effective in mitigating the issues going forward. And you only do that as time passes, right? It's not like you're going to fix something on day one and then all of a sudden it's not happening anymore. It takes time for your corrective actions to get implemented and then to start to prevent those things from reoccurring in the future. So it's kind of a catch-22, right? You want to start work immediately on corrective actions, and you want to try and get your safety management plan into the FMCSA as quickly as you can, but not too quickly where you aren't able to demonstrate the effectiveness of your corrective actions. So there's some art to it, and that's something that we've helped carriers with, as Rob mentioned, for many years. So anyway, we spent a lot of time on the current process. Let's then turn to kind of what we may be seeing coming down the pike here with the FMCSA's advanced notice of proposed rulemaking. Next step in the process would be a notice of proposed rulemaking. Usually after the FMCSA holds these types of listening sessions, the next stage in the process would be them drafting up a proposal of how they think these are going to work in the future, and then publishing that for public comment, for the public to weigh in on. And then ultimately they would publish a final rule, and then the final rule would set the new changes and then the compliance date. We're still a long ways off before this would ever take effect. The rulemaking process, depending on the nature of the rulemaking and its complexity and how much blowback it gets from various groups, dictates how long it's going to take. This one will undoubtedly be complex. It will undoubtedly get a lot of blowback, regardless of what the FMCSA proposes. There will be some group, inevitably, that's not happy about it, and they will express their displeasure in the docket. And so I have to believe that we're at least a year out from any changes to the process, if not a couple years out. Just looking back at the ELD rule, for example, that thing was like 5 years in the making after all of the litigation about it and all of the different iterations of the rulemaking. It would not surprise me at all if we see something similar come to fruition with a safety rating change. In fact, if anybody on listening in has kind of followed along with FMCSA's safety rating rulemaking in the past, you'll know that FMCSA tried to change up safety ratings back in 2016. They actually published a notice of proposed rulemaking back then that would have shaken up the process significantly. What they were proposing back then, essentially, it was more complex than this, but I'll break it down into its basics, was moving away from a 3-tier rating system and to a single rating of either unfit. That would be the only rating, unfit or not rated. And the way that they were proposing to assign that rating of unfit or not was in part based on your CSA scores as a fleet. Right now, your CSA scores only dictate whether you get escalated for an audit. They don't dictate whether you get a safety rating or not. But the proposal in 2016 was we are going to assign safety ratings in part by CSA scores. The worse your CSA scores, the more likely it was you were going to get an unfit rating. And they had there was a whole methodology to it. It wasn't just scores above the alert thresholds as you might think. They had set special thresholds where if your scores exceeded those special high thresholds in a particular month, then you get an unfit rating. But it was still going to carry the same consequence. If you got an unfit rating out of CSA scores or also an audit, they were still going to have an auditing component to it, then you were going to be placed out of business. Whole idea with this is kind of coming back to where we're at now. Why is the FMCSA doing this? Why were they proposing it back in 2016? They want to broaden their reach. As we said at the start, FMCSA is hamstrung to be able to conduct any significant percentage of audit any significant percentage of the carriers that they regulate. So they just don't have enough folks to be able to do that. So how do they widen their reach? Well, in 2016, they thought the best way to do that was to tie your safety rating, at least in part, to your CSA scores. We have CSA scores for a much bigger percentage of regulated carriers out there than have safety ratings. There are some carriers, particularly small ones and newer ones, that don't have CSA scores because they don't have enough inspection data in the system, but lots and lots of carriers have CSA scores. So the idea was if we start tying safety ratings to CSA scores, then we're going to have a bigger percentage of carriers that get a safety rating. And that, as you would expect, that led to a lot of outcry within the industry. Several different groups, including ATA and Congress, got involved, and ultimately FMCSA had to withdraw that rulemaking back in 2016. It was also around the same time that the FAST Act was passed by Congress, which essentially slapped FMCSA on the wrist for their CSA program, told them they had to go get it evaluated by an independent third party. And so that's where we're at now. That analysis of CSA has been done. FMCSA has proposed changes to the SMS system based in part on that study. And we're waiting on those changes. And so I know we're about out of time here. And so to kind of wrap things up here is my kind of crystal ball outlook on this, where I think this is headed. And FMCSA's most recent notice about the listening sessions and everything like that has pretty much all but confirmed what I've been thinking the FMCSA was going to do for the last year or so. FMCSA has proposed those SMS changes. I have to think that their thought process is, hey, we've now taken the steps that Congress told us to take to fix SMS. And once we get those rolled out, then Congress should have no more concerns with us potentially tying a carrier safety rating to the SMS scores. That's got to be their thought process. And so I think they are starting to then move both balls down the court, right? They're moving the SMS changes down the court. Now, right behind it is going to be the safety fitness determination. And what we see in the notices that FMCSA has published on it so far is that they are, again, toying with potentially tying a carrier safety rating in part to their CSA scores. What that will look like, we don't know. All we can do is guess based at least partially on that 2016 proposal, but I think that's where we're headed, and that's one of the main questions that they're asking in the advance notice of proposed rulemaking and in the listening sessions. That was a lot of me talking. Rob, any thoughts on tying carriers' safety rating to CSA scores if that's ultimately where we land with this?
No, not really. Not unless, provided they have their kinks worked out, I think it'd be all right.
Yeah, I think that's a question, right? I mean, my biggest concern with it has always been the due process, putting aside the problems with the CSA platform that we've been complaining about for years, and some of which the FMCSA is ostensibly fixing with their SMS proposed changes. My concern still remains due process, the lack of due process available to carriers to be able to rectify erroneous violations from roadside inspections. That data is what's generating CSA scores. And it turns out that a lot of those violations, it's just a matter of fact, a lot of the violations are incorrect. that get written up on roadside inspection reports. I don't think anybody at FMCSA could deny it, or at their state law enforcement partners. A lot of them are incorrect either factually or legally. And the problem we have now is that the data queue system is the only system available for carriers to contest that erroneous data. And as we know over the years, the success rate on data queues is very low because there is no due process. There's no appeal process. It's those appeals are decided by the very same agency that wrote up the violations to begin with. They are not inclined to change their mind on it, regardless of what evidence you present to them that they got it wrong. They are very biased. And so until we get that system fixed, I see in no way could we tie a carrier's safety rating to their CSA scores. If the carriers do not have effective due process to challenge erroneous violations that are jacking up their CSA scores, how could we possibly tie their ability to continue operating to erroneous data with nowhere to appeal it? Now, obviously, FMCSA has started to think about this because they have proposed an independent appeals board for the data queue system. They proposed that last year. Haven't heard anything more about it. I suspect that they would plan to move forward with that appeals board kind of along the lines of the CSA changes and also the safety rating changes. But until we see what the independent appeals board is going to look like and where carriers can take those appeals of their roadside violations, I just do not feel comfortable tying a carrier's safety rating to CSA scores.
Yeah, that's those kinks. And then there's the other aspect of some carriers. I actually had a call this morning, which we'll talk about later, from LinkedIn. A guy on LinkedIn just called and said, hey, what is data queue? I can challenge these things. So there's also the ignorance aspect to not all carriers have the knowledge base to say, oh, there is some form of due process. Maybe it's incomplete and mostly unsuccessful. But there's a lot of carriers that don't exercise that due process that does exist.
Yeah. And there is certainly a possibility, I think this was proposed in 2016, that even if we tie a carrier's safety rating in part to CSA scores, that there would still be some other appeals process available to them, similar to what we have now, an administrative appeal through FMCSA's headquarters or some kind of a safety management plan, corrective action type plan. I think those absolutely have to be part of the equation. I just worry, though, if we're going to say a carrier that has CSA scores at a certain level, they automatically get an unfit rating, and now they're out of business. While then now they have the option to go appeal it or do corrective actions. Well, they're out of business. What incentive do they have anymore? Their workers aren't getting paid. They have no revenue coming in. We got to get all that figured out, and that's the biggest part that I'm concerned about. But we'll just have to see where that goes. Again, we're very early on in the rulemaking process. Advance notice of proposed rulemaking. Be sure to attend those listening sessions if you're interested in participating or at least learning more about what the FMCSA may have in store. I'd encourage you to do that. We will continue to report on it. I'm going to attend the listening sessions and see what I can glean from it. But stay tuned. Best way to keep up to date with everything that we got going on at Trucksafe, including those types of updates, is through our newsletter, trucksafe.com/subscribe, and you will get that type of information sent right to your inbox. So I'd encourage you to do that. Anything else we need to hit, Rob, before we wrap things up? You got to get back out on the road.
I don't think so. I think that's it.
All right. Well, thanks everybody for tuning in today. Really appreciate it. Stay tuned for announcements about future shows. You can read guest bios, watch prior episodes, and everything over at trucksafelive.com. We will look forward to seeing you next time. Thanks, everybody. See ya.
Thanks.